Okay, so um, there's a good bit of the process of the trial procedure, starting with the pleading and the pretrial motions and things that I'm not going to spend a lot of time on. But what I do want us to take from that is that litigation is time consuming, it's slow, and it's expensive. All right, particularly post COVID. In some areas, particularly for civil jury trials, they haven't been any in years because the jury pool for um, criminal trial is the same as the jury pool for civil trials. And when you couldn't get juries together due to COVID, the number of people that they could get to serve on juries all went towards criminal trials because generally you've got somebody locked up. Whereas with civil trials, people are living their lives and they're just waiting on the court system to rule. Suffice to say that litigation is expensive, slow, and often unpleasant. All right. So most disputes are settled in what we'll term alternative dispute resolution, or ADR, which can be much cheaper and much faster. There are many types of alternative dispute resolution. We'll talk about three, right? And I'll need you guys to understand these three. The first and most informal is negotiation. So, and again, this can be between the parties or it can be between the parties' attorneys. And it's just like, so, if my attorney believes I have a claim against you, or I believe I have a claim against you, I can call you and say, I think that you've caused, $5,000 in damage to my vehicle. I'll send over the estimate. Are you willing to pay the $5,000? And if you say yes, we've just negotiated that issue away and we'll never file in court. All right. And that can be done with or without an attorney. Mediation. So the thing to remember about a mediator is they cannot make a decision for you, but they are often experts in the type of claim that you believe you have. So the mediator can help you and say, if you go to court, this is most likely what's going to happen. So it's in your best interest to agree to something in that same ballpark and then save court cost and legal cost and all of the stuff that comes with actually going to court. So think of the mediator as a facilitator, somebody who helps the parties, one, come to a decision based on, and usually using their knowledge of what happens if they sue each other in court. But they can't force either party's hand, right? So the mediator cannot make somebody agree, and they can't decide the case. The third, and you could theoretically see an issue or controversy where you start negotiation, it fails, you proceed to mediation, that fails, and then you end up in arbitration. All right. Arbitration is a lot like mediation, in which the arbitrator will try to help the parties come to a resolution. But if they are unable to, the arbitrator does have the authority to make a binding decision. Right? And generally, you can't appeal unless you make an allegation that the arbitrator did something wrong or breached their contract with both the parties. Generally, you cannot appeal an arbitration award. All right, but that's the third type of alternative dispute resolution that we will be responsible for. Okay,